Good morning, my name is Angus Crowe. I'm a solicitor at Slater and Gordon Lawyers, and in today's presentation, I will be discussing the current state of medical negligence law in Queensland, specifically how it relates to medical consumers who have received a false negative cancer diagnosis. This presentation is to the Misdiagnosed Cancer Association, Queensland. The Misdiagnosed Cancer Association of Queensland are a group of patients who have received incorrect diagnoses of cancer, a false negative. A meaningful portion of the group have received a false negative cancer diagnosis, and I will address the adequacy of negligence law in Queensland and its ability to serve the needs of patients who have received a false negative cancer diagnosis from medical professionals. The presentation is concerned with patients who have received this incorrect diagnosis after 2000. In Queensland, the false negative breast cancer diagnosis rate was 6.3 per 10,000 participants in 2018. While later tumour growth may contribute to this aligns with the estimated false negative rate where cancer was already present at the time of the initial screening. A population study found that 49.4% of cancers were screen detected, while 19.8% were interval cancers identified within 2 years of a negative mammogram. If Queensland's false negative rate approximates the global average, then applying this proportion to the 35,325 cancers diagnosed in 2022, it suggests that approximately 22 patients in 2022 may have initially received a negative screen before later being diagnosed with cancer. The figures contribute to the loss of 865,891 years of healthy life of Australians due to cancer, as calculated by the Australian Burden of Disease. False negative cancer diagnosis can have devastating effects on a person's health and well-being. The most immediate consequence is that the disease can progress unchecked, often resulting in a more advanced and aggressive cancer by the time it is eventually detected. Evidence from Queensland shows that the interval cancers, those diagnosed after an earlier negative screening result, are much more likely to be late stage and high grade, with patients facing more intensive and taxing treatments as a result. In the meantime, the individual may endure prolonged physical discomfort, uncertainty, and a decline in daily function, often becoming more reliant on others for support. This loss of independence can cause emotional distress. In Queensland, the law of medical misdiagnosis provides remedies only where gross negligence can be established, reflecting the adversarial system's commitment to corrective justice. However, this framework fails to adequately serve victims of false negative cancer diagnoses whose profound losses arise without gross fault by medical professionals. This presentation will explain the current negligence law in Queensland and the way that it applies to patients who have received a false negative cancer diagnosis, the possible outcomes for patients and other interest groups who interact with negligence law will be analysed and will highlight areas of the law that may be critiqued and demand reform that addresses any shortcomings in the operation of law. In Queensland, negligence law, including false negative cancer cases, requires patients to prove 5 elements against medical practitioners. While informed by common law principles, the Civil Liability Act of 2003 Queensland is the primary authority and prevails over common law where inconsistencies arise. First element to be proven is that the medical practitioner owed a duty of care to the patient they misdiagnosed. A duty of care is where the medical practitioner owes a legal obligation of responsibility to the medical consumer. This is required under Section 9, subsection 1 of the Civil Liability Act. However, it is established with common law principles. As per Rogers and Whittaker, medical practitioners owe a duty of care in their professional advice or judgments to patients. The second element is a breach of duty. Established under Section 9 of the Civil Liability Act. The breach involves a 2-step process. The first is determining the general standard of care under Section 9, subsection 1, which requires precautions against material risks, and second, assessing whether the defendant failed to meet that standard. A risk will be material where it was A, foreseeable, B, not insignificant, and C, a reasonable person in the defendant's position would have taken precautions. In Wyong Shire Council, the High Court confirmed that a risk is foreseeable and significant if it is not far-fetched or fanciful, and that even unlikely risks may still be foreseeable. Precautions must therefore be taken against foreseeable risks in diagnosing and warning of the inaccuracy of a cancer screening test as per Wyong Shire Council. Or C, Section 9, Subsection 2 of the Civil Liability Act for whether a reasonable medical practitioner would have taken precautions is assessed objectively by reference to the probability and seriousness of the harm, the burden of taking precautions, and the social utility of the activity. In the medical context, this means ensuring not only technical competence in diagnosis, but also safeguarding the autonomy of medical consumers through adequate warnings of material risks, as affirmed in Rogers and Whittaker. Once the general test is satisfied, the more specific test then applies. Section 21 of the Civil Liability Act imposes a proactive duty on medical practitioners to disclose material risks, A, as disclosure is necessary for a patient to make a reasonably informed decision about treatment, and B, the practitioner knows or ought reasonably to know that the patient would want that information before deciding. There is a clear duty to disclose the material risks of treatment in the diagnosis procedure of cancer. The second part of the element surrounding breach is that the conduct of the medical professional failed to meet the established standard. Under Section 9, Subsection 1 of the Civil Liability Act, a breach of duty arises where the defendant fails to take precautions a reasonable person would take in the circumstances. In the medical context, this includes false negatives, where the practitioner either misdiagnoses or fails to warn the patient of the risks associated with test inaccuracy. This is the most important stage for plaintiffs, as the medical practitioners often meet their standard of care as part of their common practice, especially following Rogers and Whittaker. It is only in the grossly negligent cases that injured medical consumers are able to be successful in traditional litigation. Third element of negligence is causation, which requires proof that the defendant's breach caused the plaintiff's harm under Section 11 of the Civil Liability Act. In medical misdiagnosis, this means showing the practitioner's failure to meet the standard of care, such as misinterpreting a test, was a necessary condition of the injury. Causation may also arise where a practitioner fails to warn of a material risk, like diagnostic inaccuracy, and the patient would have declined treatment if properly informed. The test is subjective, focusing on what the patient would have decided. Statements made by the medical consumer afterward are generally inadmissible unless it is against their own interest. It is important to note that a mere loss of chance of a better outcome, which is speculative, is not recognized as an injury, as established in Tabbitt and Gett. This is very important, as a loss of chance for a better outcome is a primary concern as a potential damage for people who have had to delay their cancer treatment, which may have led to a more developed and dangerous tumor, which they are simply unable to prove the effect of. Unless this loss of chance of a better treatment was greater than 50%, then it is not recognized by the court. When retrospective comments are inadmissible, proving how the medical consumer would have responded to an adequate warning may impose an unduly heavy burden on the plaintiff, who must rely on other evidence to show they would have acted differently, which might simply not exist. The medical consumer may also face similarly unruly evidentiary burdens to show that a loss of chance of a better treatment was more than 50% likely to occur, as this is a matter of medical opinion which possibly and quite commonly is not able to be proven. In Australia's fault-based system, the injured medical consumer must prove they suffered damage as a result of the medical professional's negligence. The CLA imposes statutory limits on recoverable damages, and they can only be given for harm that occurs under Section 52 of the Civil Liability Act. These damages include personal injury and economic loss. Other damages, such as pain and suffering or loss of amenities of life, are subject to the injury scale under Section 61, from 0 to 100 based on case law outcomes. For defences, Section 22 of the Civil Liability Act provides that the professional standard of care may be influenced by widely accepted peer practice, even if not universally endorsed. The court must be satisfied that the practice is an identified professional practice, but retains authority to reject it if it is irrational or contrary to law. This section does not apply to failures to warn, but may still be relevant in false negative diagnosis cases. Furthermore, under Section 16 of the Civil Liability Act, a medical practitioner is not liable where the harm results from an inherent risk, being a risk that cannot be avoided through the reasonable care and exercises of skill. In the context of a false negative diagnosis, if the practitioner followed proper procedure and the error arose from factors beyond their control, such as an equipment failure, then liability will not be attached. The High Court ruling in Rogers and Whittaker makes injured parties more likely to succeed in court. However, given that the law requires gross negligence by the medical professional, few injured medical consumers claim damages in litigation, as they cannot satisfy this evidentiary burden. This adversarial litigation is slow, expensive, and can be taxing on injured medical consumers. And while the adversarial system promotes corrective justice, this is inappropriate in the cases where there is no gross negligence to be corrected. The High Court in Rogers and Whittaker confirmed that courts, not the medical profession, set the standard of care. Although criticised for inviting more litigation, the decision enhanced accountability without fostering biased expert testimony. Fears of doctors leaving practice drove the IP Review and the Civil Liability Act, which balanced fairness to doctors with access to justice. In false negative cases, however, medical practitioners are rarely grossly negligent. The law fairly defines doctors' duties, but litigation is an inadequate vehicle for compensation. Reform should leave the standard of care intact while creating a system that ensures injured medical consumers can obtain fair redress without unfairly burdening practitioners, who are often described as the second victims of adversarial litigation. The current resolution of false negative cancer diagnosis claims within Queensland's adversarial medical negligence framework is outdated and fails to embody a patient-centred approach. Litigation is a poor vehicle for justice. It disproportionately disadvantages marginalised groups who already face greater barriers to initiating and sustaining legal action. The fundamental problem is that injured medical consumers receive little protection under Queensland's negligence law because the system requires proof of gross negligence by the medical practitioner. This evidentiary burden is exceedingly high and rarely satisfied, especially as most diagnostic errors stem not from gross negligence but from systematic or technological limitations outside the medical professional's control. To address these gaps, Queensland should consider a no-fault system grounded in distributive justice. Unlike the adversarial model, which centres blame on individuals, a no-fault system distributes the burden of injury across society. This approach is fairer because false negative diagnoses arise from systemic risks rather than deliberate and individual misconduct. A no-fault system requires only two elements to be proven. The first is that the plaintiff has suffered an injury, and the second is that the injury arose from the defendant's actions. No fault must be proven. These elements are far less onerous than those demanded in adversarial proceedings, making compensation more accessible for medical consumers. International evidence demonstrates that no-fault schemes can succeed. Both the US and New Zealand have implemented models that are more cost-effective than adversarial litigation, while also ensuring swifter and more compassionate compensation. Crucially, such systems prioritize patient welfare and restore dignity to injured medical consumers, aligning justice with fairness rather than procedural technicalities.